Just when we thought justice was finally on its way for George Floyd and his family, Derek Chauvin has filed a request for another trial. Chauvin was convicted of second-degree murder and other charges last month in the death of Floyd. And attorney Eric J. Nelson says in the motion that Chauvin was denied a fair trial due to, quote, prosecutorial and jury misconduct, and as well as errors of law at trial, and that the resulting jury's verdict was, quote, contrary to law. Joining me to break this all down is Dr. Laura McNeal. She's BNC's chief legal correspondent. Dr. Laura, good to see you. This is stunning and frustrating. 2 weeks ago, we were jumping up for joy. People said, look, even if this ain't justice, this is accountability. Even if this ain't accountability, it's better than what we had before. At least Chauvin is being held accountable for what he did. And now we're hearing this news. And of course, this news is unfolding after it was revealed that Brandon Mitchell, who was a juror, attended last year's March on Washington rally. That wasn't necessarily the issue, but there's a picture of him at the rally wearing a shirt that says, "Take your knee off our necks, BLM." Explain to me, first of all, how, if so, how this is a problem.
Yeah, so the problem is the Constitution guarantees that everyone has the right to a fair and impartial trial. And so what Eric Nelson is trying to establish in this motion, Mark, is that Derek Chauvin didn't have a fair and impartial trial because that juror, Brandon Mitchell, had already made up his mind about his guilt. He was already having some very strong feelings about police officers. I mean, the shirt, if it had just said Black Lives Matter, maybe we'd be great and totally in the clear. But because it said, get your knee off our neck, which was a message to all police officers, Eric Nelson is saying his client didn't get a fair trial. And so the judge is going to have to decide based on that and several other grounds that were listed in that motion whether or not that is the case. If so, he will rule a mistrial, which again, you say we were jumping up and down. I was doing the electric slide downtown Minneapolis just 2 weeks ago, so I didn't see this coming.
How much of this hinges on the jury instructions, the jury questionnaire, etc.? It would seem to me that if the juror lied, if the juror misrepresented his history, his activism, his engagement, then it could certainly look as if he intentionally got on this jury for the purpose of convicting Derek Chauvin. But if the instructions weren't clear, or if they were clear and didn't demand him this kind of disclosure, then isn't this just regular First Amendment, free speech, freedom of assembly, etc.?
It is. You're going to make me recruit you for law school. Absolutely. Essentially, Mark, he didn't lie. Like, I went back and looked at that original jury questionnaire, and what they asked Brandon was whether or not he attended any rallies in Minnesota. That's their fault if they didn't make that more broad and say D.C. The rally he attended was in Washington, D.C., so he didn't lie on the jury questionnaire. So in that sense, he is in the clear. The question will be whether or not the judge on the appeal will consider things such as asking some of the members of the jury, when you were in deliberations, did you feel that Brandon came with a clean slate, or had he already made his mind up? Did he consider the facts and apply them to the law? And that's what the standard is that the judge will consider in this case.
So it sounds like this is a long shot. When I first saw the headlines, I was worried. I said, look, if this dude pretended he wasn't at the rally and he was, if he said he hadn't heard about the case and he's sporting, you know, T-shirts with, you know, with this kind of language on it, we're in trouble. But from what you're telling me, this is more of a, I won't go so far as to call it pro forma, but this is a common type of appeal that people make after they're convicted, no?
Yes, and so we expected Eric Nelson to do this. Every defense attorney does that. That's what they're paid for. So they're supposed to try to appeal and get a mistrial. The question is this enough? And my legal expertise would say no. Again, unless there's some other evidence, I think that we are in the clear. If not, my goodness, Mark, to start this all over again would be such a disadvantage, because now the defense has seen the prosecutor's whole playbook. So every play they made, all their top experts, it would put them at a very high possibility of having a jury that doesn't convict Derek Chauvin a second time. You only need one juror to hold out, and now they know how to regroup in the event that there is a new trial.
And just to be clear, if there were a new trial, it would be the result of a mistrial in this case. We're typically familiar with mistrials being something that happens before the jury reaches a verdict. Would this actually be a formal mistrial, or is there some other legal framework for this?
Yeah, so no, it'd be a formal mistrial based on appeal. So essentially saying that based on information that was received after the verdict, the defendant in this case, which is Derek Chauvin, didn't receive a fair and impartial trial as guaranteed by the Constitution. Again, a long shot. I don't want to freak everybody out, Mark, but still something we need to keep our eye on for sure moving forward.